Hello and welcome. My name is Alan, and today we are completing the rest of Section 1, no, Article 1 of the Constitution. My mind is like, yeah, oh, back. Anyway, I'm going to read the remainder of Article 1, which is just two sections here from my constitutional law book. So, this is Section 9 of Article 1, Paragraph 1. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. So, let's read this again. Migration or importation of such persons as any of the states, the original 13, now existing shall think proper to admit, shall not be prohibited by Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. And this is wholly a slavery clause. We will not ban the importation of slaves, but we're going to charge you for each one. Article 1, Section 9, Paragraph 2. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. One of the big moments people try to talk about as far as the suspension of the writ of habeas corpus, that is when during the Civil War, I believe it was, when Lincoln suspended habeas corpus. Give me a minute here. Habeas corpus. The writ requiring a person under arrest to be brought before a judge or into court. So they have a right to a trial. Or at least a hearing. But one of the things you'll often hear talk about is Lincoln's suspension of habeas corpus during the Civil War. Many people get all upset about that. So, there it is. Yeah. April 27th, 1861, Abraham Lincoln suspended the writ of habeas corpus between Washington, D.C. and Philadelphia to give military authorities the necessary power to silence dissenters and rebels. So he suspended it for um, people in the North, so there wouldn't be any pushback. Which there's still a lot of argument against even today. We were in a rebellion of sorts, if you want to consider the secession of the South a rebellion. Although many would argue, oh, it's a war for, uh, attempted independence. But yeah, there's a lot of gray areas with Lincoln's suspension of the writ of habeas corpus. Anyway, Article 1, Section 9, Paragraph 3. No bill of attainder or ex post facto law shall be passed. So, no bill of attainder. A bill of attainder, also known as an act of attainder or writ of attainder or bill of penalties, is an act of legislation declaring a person or group of persons guilty of some crime and punishing them, often without a trial. So again, this goes to that we want to try to offer a person that right to be to have a trial, especially of their peers ex post facto. I think that's claiming someone's guilty and then making a law against what they did. Yeah, having retroactive effect or force. Ex post facto law is a law that retroactively changes the legal consequences of actions that were committed or relationships that existed before the enactment of a law. So the law tries to claim, well, going back, even though the law hadn't existed yet, it covers back this far. Yeah. But the United States did not want those happening. Anyway, Article 1, Section 9, Paragraph 4. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration there herein before directed to be taken. So, yeah, no capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. So it's a rule um, on taxes. Capitation itself only means the payment of a fee or grant to a doctor, school, or other person or body providing services to a number of people, such that the amount paid is determined by the number of patients, students, or customers. So, in this case, a tax by a number of people cannot be set until we have a number decided of people that there is. Come on, quit trying to scoot the page here. Article 1, Section 9, Paragraph 5. No tax or duty shall be laid on articles exported from any state. Um, so if a state exports its goods to Canada, Mexico, don't tax that. That is within the state's rights, is what the Constitution's saying. Um, Article 1, Section 9, Paragraph 6. No preference shall be given by any regulation of commerce or revenue to the ports of one state over another of those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. So yeah, um, because just entering one port shouldn't, if the ship is from somewhere else, they shouldn't have to pay extra taxes. We want this to kind of be a uniform country, with everything going on. So, Article 1, Section 9, um, Paragraph 7. No money shall be drawn from the Treasury but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. So, only in the cases of appropriations uh, created by law shall money be withdrawn from the U.S. Treasury. And basically, we need a balance sheet showing deposits and withdrawals from the Treasury from time to time. We want a record. Article 1, Section 9, Paragraph 8. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present emolument, office, or title, excuse me, of any kind whatsoever from any king, prince, or foreign state. Essentially, part of the emoluments clause in the Constitution. We are not nobility, we are people. Congress, the president are not nobility, they are people. They are directly responsible to the people. And accepting a lot of these things, a lot of these titles and such can be illegal per the Constitution. Like, what did Saudi Arabia try to award Trump with? I can't remember what it was, but yeah. Let's read this again. No title of nobility shall be granted by the United States. So again, nobody is earls or dukes or bishops, barons, so forth. And no person holding any office of profit or trust under them without the consent of the Congress, except of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. So, our members of Congress, president, this section is particularly noting to Congress. I don't know if it leans towards the president as well, but I would assume it would be similar. But yeah, foreign presence, titles, emoluments, offices. No, that is not your job as a representative of the United States. And that goes against the Constitution. Again, the only ones you can really think of as presidents, Trump with the thing for Saudi Arabia, that's probably very questionable for this. Um, Obama, where he accepted the Nobel Peace Prize while he was still in office. That's possibly a violation of this. If it would have been after his presidency, that would have been fine. But then their view of him might have very well changed. But yeah. I think this particular section, though, is mainly talking about members of Congress, since Article 1 is about Congress. Now, Article 1 and the final section of it, Section 10. Article 1, Section 10, Paragraph 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debt, pass any bill of attainder, ex post facto laws, or laws impairing the obligation of contracts, or grant any title of nobility. See, they don't want this nobility on the federal level, they don't want it on the state level. The Duke of New York. They don't want that kind of thing. And plus, a lot of what the states do, they say they can't enter into their own treaties, their own alliances, or a confederation, which is why the um, Civil War was considered a bit illegal because it was a confederation of southern states. No letters of marque and reprisal. They um, can't coin money, emit bills or credit, or make anything but gold and silver coin a tender in payment of debts. Because remember, one of the reasons the Constitution was passed in the first place is because each state had its own form of currency under the Articles of Confederation. Very confusing and made it difficult to pay the Minuteman armies. But yeah. Article 1, Section 10, Paragraph 2. No state shall, without the consent of Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. So they don't want um, most states trying to make a profit on imports and exports. They said the only reason we'll allow you to put a little tax on it is what's necessary to help, what they say, for executing the inspection law. And I think this is mostly counting for interstate commerce because they want it to be a fair and free event. Because remember, when the country first formed, what became the states had been their own independent colonies and operated like their own countries, more or less. And under the Articles of Confederation, they still had that amount of freedom to a point. The Constitution ends that. But yeah, last paragraph we're going to read Article 1, Section 10, Paragraph 3. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war unless actually invaded or in imminent danger, as will not admit of delay. So again, the states by themselves cannot, unless Congress consents, lay any duty of tonnage, the shipping, uh, you know, you cannot lay taxes on how much they have brought in. So unless we give consent in Congress, they can't keep their own troops because, again, you got to remember during the Revolutionary War, it was often the blank of Vermont or Ethan Allen and the Green Mountain Boys, which is also from Vermont. Um, even though Vermont wasn't until later. So there wouldn't have been a thing of Vermont during the Revolutionary War. It would have been of New Hampshire. But the Green Mountain Boys still existed. And what is present day Vermont, which the state of Vermont is literally uh, a form of the French word Vermont, Green Mountain. But yeah, the Army of New York, the militia of Massachusetts, whatever. These states often had their own military. But as they all formed and became one country, this is where a lot of our problems came into being because the states ran independently for the most part, even under the Articles of Confederation, making it difficult to have a central power pay troops and this and that. But yeah, they can no longer keep their own troops or ships of war in time of peace. So, you can, I think, you can pull up your own troops and ships of war when we're at war. Enter into any agreement or compact with another state or with a foreign power. So, again, they don't want the states running this interstate business just between themselves because you're going to be part of a whole. You are a state still and have certain rights and freedoms, but there's certain sessions you have to give to Congress. Or engage in war unless actually invaded or in such imminent danger as will not admit delay. So also the state cannot claim it is at war um, unless it is invaded or trying to wait on troops is not a possibility. It's an emergency. Which I do think, if I remember right, each state has its own National Guard. Kind of curious. Do state National Guard count as military? Under current law, the respective state National Guards and state defense forces are authorized by Congress to the states and are referred to as troops. Let's see. But they're under the National Guard Bureau, so they're still part of the National Guard. It's just they're each state's a portion or apportionment. Uh, National Guard Bureau is a federal instrument responsible for the administration of the United States National Guard, established by the U.S. Congress as a joint bureau of the Department of the Army and Department of the Air Force. Created by the Militia Act of 1903. The National Defense Authorization Act for fiscal year 2008 elevated the National Guard to a joint function of the Department of Defense. It also elevated the chief of the National Guard Bureau from Lieutenant General, 3 stars, to General, 4 stars. And the appointment of General Craig R. McKinley of the U.S. Air Force, with the appointment of Craig R. McKinley. The National Guard Bureau holds the unique status as both a staff and operation agency. I was wondering because I know often it's not necessarily in military regards, it's sometime in infrastructure or natural disasters. They often call in the National Guard. So, okay, but that was just a query on that regard. But that is Article 1 done of the Constitution. Next time we do another constitutional video, we'll be working on Article 2, which deals with the presidency. Do this. But that will be it for the video. I'll see you all in the next one. Until then, as always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. I will be listing some links in the description below the video. But until next time, later.